arrive.
I just want you and Amanda in the room because I'm going to say something to both of you in the introduction.
Okay. Oh.
Okay, no problem. Hey, good morning, everyone.
Is Sharon introducing us?
My name is Jonathan Enton, and I wear multiple hats, or I will be wearing multiple hats today. I'm the academic dean of the law school, and I'm also faculty advisor to the Law Review. But right now, I am supposed to do my best impersonation of our dean, Bob Rawson. Bob, unfortunately, cannot be here today, and he sends his regrets about that. Bob is on the road doing the things that deans are supposed to do so that the rest of us can do the things that we really like to do. But on behalf of Dean Rawson and the law school, I want to welcome you all to this year's Case Western Reserve Law Review Symposium on reproductive rights, human rights, and the human right to health. This symposium is being held, perhaps fittingly, on the 37th anniversary of the decision in Roe against Wade, which undoubtedly will be an important part of the background to the discussion today. This is one of a long series of symposia sponsored by the Law Review over the last couple of decades on topics as diverse as the right to privacy 100 years after the publication of the classic Warren and Brandeis article, religion in the public schools, the new federalism after United States against Lopez, presidential power, judicial independence and judicial accountability, corporations and their communities, and last year's program on access to the courts in the Roberts era. Today we're going to have several sessions addressing the issues in reproductive rights, human rights, and the human right to health. One session on whether the human right to health includes reproductive rights, another on reproductive technologies, and another on reproductive autonomy. We'll also have a keynote speech right after lunch by Professor Reva Siegel from Yale Law School, and there will be a reception at the end of the day where we'll be able to mingle with all of our speakers. Before I yield the floor, I want to recognize two of the Law Review editors who have played a pivotal role in organizing this program. Matt Hooley, who is the symposium editor, and Amanda McMurray-Rowe, who's the editor-in-chief. As I said, this is better for them than being academic dean. My view is everything around here that goes wrong is the academic dean's fault, but we can say everything that goes right today will be to the credit of Matt and Amanda. Having said that, I'm going to yield the floor to my colleague, Sharona Hoffman, who was my former senior academic dean and who has been and still is the co-director of the Law Medicine Center. And Sharona will introduce our first session. So, Sharona, all yours.
Good morning, everyone. Our first session is going to focus on two questions. What is a human right to health, and does it include reproductive rights? We have three speakers today, all of whom are very, very accomplished. First, Lance Gable will speak. He is an assistant professor of law at Wayne State University, where he teaches public health law, bioethics, torts, and more. He works with the Centers for Law and the Public's Health, which is a collaboration between Georgetown, Johns Hopkins University, the World Health Organization, and the Centers for Disease Control and Prevention. Our second speaker is Cynthia Soohoo, who is director of the U.S. Legal Center at the Center for Reproductive Rights in New York City. Her career has included landmark litigation in the private sector, directing the Bringing Human Rights Home project at Columbia Law School, and work on human rights issues with the UN, the Inter-American Commission on Human Rights, and the American Constitution Society. Our third speaker is Benjamin Mason Meier, who is a professor of global health policy at the University of North Carolina, UNC, in the Department of Public Policy, where he teaches ethics, health and public policy, and human rights. Professor Meier also holds positions with the UNC Gilling School of Global Public Health, the UNC Institute for Global Health and Infectious Diseases, the UNC Center for AIDS Research, and the Georgetown University O'Neill Institute for National and Global Health Law. Our speakers will speak for about 15 minutes each, and we will have questions after that, so please hold your questions until the end. At the conclusion of this session at 10:30, we're going to have a 15-minute break, followed by the panel on reproductive technologies at 10:45. Lance.
Well, good morning, everyone. Thank you, Sharona, for the nice introduction. And I want to thank Case Western Reserve School of Law, as well as the Law Review, for the invitation to participate today. When I first heard about this symposium, I was really intrigued by the question posed by this panel, the idea of trying to evaluate whether reproductive rights were a part of the right to health. And my initial reaction to that was, well, yes, of course. I think that reproductive rights are a part of the right to health, in that the way that the right to health has developed over the years, especially in recent years, there's really been a broadening and a deepening of understandings of the underlying determinants of the right to health and the interconnections between the right to health and other human rights. But it also seemed to me that there was an equally important relationship that goes in the other direction, that in many ways the right to health is a component of reproductive rights, that you can look at these two concepts in ways that overlap in either direction. And so what I want to spend some time talking about today is the complex and interrelated relationship between the right to health and reproductive rights. I'm going to spend some time at the beginning trying to set out some basic ideas about how reproductive rights relate generally to international human rights law, and how they've been developed over the years, as well as how the right to health has been developed. And then I'm going to talk about how some of the really significant normative developments within the understanding of the right to health can really provide some opportunities for stronger rights claims in the context of reproductive rights. And my co-panelists are going to talk about some issues that are very related to those general themes. And so I'll probably keep my comments a little bit more broad, and they'll get into some more specifics about some of the application of the right to health in the context of reproductive rights. And so at a very basic level, when we think about reproduction and health, there's an obvious connection between the two. The ability to reproduce is preconditioned on a certain basic level of health. And at the same time, in order for reproduction to be successful, there must be the ability not only to benefit from access to health services and the existence of good health among individuals, but the ability of those individuals to make autonomous decisions about their health care and about their reproductive opportunities and desires. And so when you look at this in the context of human rights law, what you see is that reproductive health implicates a whole broad range of different human rights principles. And these principles run the gamut of human rights principles that are recognized within human rights law. And so for those of you who have experience looking at international human rights treaties, the way that these treaties have developed over the last 60 years since the Universal Declaration of Human Rights has been on a bifurcated path. There's been a division, mostly for political reasons, between civil and political rights and economic, social, and cultural rights. Civil and political rights being rights like liberty, right to life, right to privacy, right to make autonomous decisions, rights to equality and non-discrimination. On the other hand, there's been a separate track developing economic, social, and cultural rights, rights to health, rights to education, rights to protection of social welfare. And by and large, the reproductive rights movement has embraced primarily the aspects of international human rights principles, focusing on the civil and political rights. Now, this made a lot of sense for practical reasons, in that civil and political rights have consistently been more justiciable in national courts. They've been more achievable as a way to frame reproductive rights claims. But one of the things that I'd like to address today is how the right to health as an economic, social, and cultural right can be utilized to perhaps chart some new paths as to how reproductive rights can be claimed. When you look at these two bodies of rights, reproductive rights on one hand, the right to health on the other, you see that the common overlap between the two is the area of reproductive health. That reproductive rights seek to protect reproductive health through protections of autonomy and privacy and equality in reproductive health decisions, through attempts to protect access to reproductive health services, and to argue for the ability of every individual to make autonomous decisions about whether and when they would like to reproduce. And at the same time, the right to health has a very strong component of reproductive health as a subset of the kinds of conditions that are integral to achieving the right to health. And so I'd like to talk a little bit about how the right to health has evolved over the last, particularly over the last 15 years or so, and use that as a jumping off point to apply some of these new positive rights approaches to reproductive rights. So, starting with the Universal Declaration of Human Rights, the right to health has always been recognized as a core component of human rights discourse. But the Universal Declaration really only defined the right to health in a very broad way, and stating that everyone has a right to a standard of living adequate for the health and well-being of himself and his family, listing a number of specific ways that can be achieved, and specifically noting that motherhood and childhood are entitled to a special care and assistance. And so right from the start, you have at least some recognition of a reproductive component of a right to health. Now, this very broad articulation in the Universal Declaration of Human Rights was fairly ambiguous, and that the right to health was further explicated in the International Covenant of Economic, Social, and Cultural Rights, which was passed in the 1960s. The right to health in that covenant talks about the right to, among other things, maternal, child, and reproductive health, and specifically identifies the provision for the reduction of the stillbirth rate and of infant mortality, and for healthy development of the child. So this covenant creates a claim that in order to fulfill the right to health, in order to uphold that right, aspects of maternal, child, and reproductive health are integral to achieving that goal. But the real breakthrough, and what I want to spend most of my time talking about today, is the development of General Comment 14 to the Covenant on Economic, Social, and Cultural Rights, which was drafted in the year 2000. General comments are interpretive documents that provide guidance into how to interpret specific human rights. And so this general comment was quite revolutionary because it took this notion of the right to health and expanded in great detail as to what the right to health would include, and therefore what countries would be obligated to provide in order to fulfill that right to health. So the general comment, I think there are four main innovations in how the general comment interprets the right to health. And these normative expansions or explanations that have come out of this general comment, I think provide a roadmap to how to more clearly incorporate a right to health approach to reproductive rights. So first of all, the general comment looked at different strategies that needed to be adopted in order to ensure that the right to health was being upheld. And so talks about availability, acceptability, accessibility, and quality of health, of the underlying components of health. A second important innovation is that it talks about the need of states to respect, protect, and fulfill the right to health. And so states are not only obligated to themselves not violate the right to health, but they also have to ensure that third parties don't engage in acts that undermine the right to health. And they also have to take affirmative steps to fulfill the right to health. And so what does that involve? And these are the two additional innovations that come out of this document. The first thing is that the right to health is not just some kind of general idea of accessing health services or just the ability to make decisions about health services. It's also the ability to partake of and have available the underlying determinants of health. And so the underlying determinants of health include things like access to clean food and water, access to appropriate housing, to appropriate societal conditions, environmental conditions that are preconditions for health. And so in the context of reproductive health, these underlying conditions, these underlying determinants of health can be thought of as all of the different social support structures, including access to appropriate nutrition during pregnancy, access to different healthcare services that might support good reproductive care, whether we're talking about a pregnancy that is being brought to term or a pregnancy that's being terminated. So it would include abortion services that were safe and all sorts of related kinds of health services and underlying determinants within food, housing, and social support. Beyond that, there's also recognition in this general comment that there's an interconnection between the right to health and many other fundamental human rights, in fact, all other fundamental human rights. And so these other human rights are integral components to achieving the right to health. And so in order to have the right to health, you also have to have protections for rights to privacy, for rights to autonomy and liberty, that protections from violence are important to the right to health, that access to education and access to information about reproductive health services and options are going to be an integral component to the right to health. And so by looking at this broad and interconnected normative structure that the right to health now includes, this has been further elaborated through several reports that the Special Rapporteur on the Right to Health has developed in subsequent years. And so I guess to sort of take this new broadly conceived idea of the right to health, this allows for some important possibilities in how reproductive rights can be pursued through different legal venues. At the international level, there's an opportunity to continue to develop the normative content of a right to reproductive health grounded in an affirmative right to health. And this would be somewhat of a departure, since reproductive rights have traditionally focused on more of the civil and political rights discourse. And I think that the potential advantage here, and this is something that I'm going to develop further in my paper, is that by having this much broader and deeper understanding of the right to health, it gives that rights claim more weight. It gives it more rhetorical force and also more substantive force as a rights claim. And recognizing its interconnection with these other human rights that may have been more widely recognized in different jurisdictions in prior decisions also gives an opportunity for the right to health to be pulled together more closely with the traditional universe of reproductive rights. So another potential advantage of this approach is not only in the justiciability of the rights, in other words, whether the rights will be enforceable in court at a national level. And Cynthia is going to talk more about justiciability issues in her presentation. It also provides a stronger foundation to make rhetorical arguments about the importance of the right to health as a cross-cutting and broadly encompassing concept for reproductive health. And so by focusing on the reproductive health aspects of reproductive rights, there can be creation of new policies at national levels and at the international level that explicitly use a right to health argument, or that right to health claim, to strengthen and move beyond the traditional negative rights approaches that have been taken in the past. So just to kind of to elaborate on that for a minute. Excuse me. I did want to mention that in order to continue this development of the application of the right to health to reproductive rights, there should be a much more concerted effort, not only to develop these ideas within international documents and international agendas, but also within specific levels within national court systems, national policymaking, and regional human rights systems have a particularly important role to play. The regional human rights systems have taken the lead in creating case law that supports reproductive rights, both through the European Court of Human Rights and the Inter-American Court of Human Rights. And these regional systems also provide the opportunity to expand the understandings of the right to health. National courts have also shown some inclination, in a few limited instances, to recognize the right to health and to move in that direction. And so I think there should be a concerted effort to try to push the boundaries and to bring test legislation that would recognize reproductive health as a core component of a country's obligation to fulfill the right to health within these international and regional human rights and national human rights fora. Finally, I want to comment on a couple of potential problems with this idea. The idea that you would broaden the notion of the right to health so widely and try to bring in these external human rights, like the right to education, the right to information, within the umbrella of the right to health can provide some, or can provoke some potential problems. In viewing the right to health in such a broad way, you risk diluting, perhaps, the core idea of what the right to health could be. I prefer this broad approach because I think it gives a much more substantial foundation for the right to health. But I can see that jurists in particular and policymakers who might be considering how to meet their obligations under the right to health might find this broader definition of the right to health to be confusing or too complex or too difficult to administer. International human rights obligations require progressive realization of the right to health, which means that countries don't have to fully achieve the right all at once, so they have to take steps to achieve it over time. If the right is seen to be too broad and too complex, it's possible that countries might just take the most minimal efforts and try to justify that as upholding those rights. And so I think just to conclude and to try to send things off to my co-panelists, advancements in reproductive rights and the right to health have in many ways historically traveled on these parallel tracks and have adhered pretty rigidly in jurisprudence and in policymaking focused on reproductive rights to the positive rights, negative rights dichotomy. And because of this bifurcated discourse, there really there's been erected many walls between the idea of the right to health and the idea of reproductive health. So in order to move past that and to try to create a more attainable human rights level of human rights protection for reproductive rights in this new century, I think there remains ample opportunity to deconstruct the division between the civil and political rights and economic, social, and cultural rights, and to create a more integrated conception of reproductive rights and reproductive health that protects women's health in a much more robust and profound way, that looks at reproductive rights as something that, and reproductive health as something that applies to both the decisions of men and women to make reproductive decisions and their ability to do so in maintaining good health. And so I think this is the challenge that lies ahead. In the paper, I'm going to spend a lot more time developing how the specific underlying determinants of health would apply to reproductive health, and how these connections between reproductive health and other human rights would be explicitly built and argued in making human rights claims. And so I look forward to your questions, and I look forward to the rest of the day, and looking forward to my panelists' perspective on these issues as well. So thank you very much.
Thanks, Lance. Before I start, I just want to thank Case Western for organizing the symposium and the law review. I think that this is a very timely and important topic, so I just want to thank you for creating this space and for inviting us. As Sharona said, my name is Cindy Soohoo. I'm the director of the U.S. Legal Program at the Center for Reproductive Rights. The Center is a global human rights organization that's really dedicated to ensuring that governments around the world protect, respect, and ensure the fundamental reproductive rights of women. I just want to start off by saying that, at the heart, reproductive rights are really about a woman's right to make fundamental decisions about her life and her family, and to access reproductive health services that are necessary to protect her health and to ensure that she has the ability to decide whether and when to have children. Lance did a great job of sort of setting out the international framework of the right to health and how reproductive rights relates to that. I just want to reiterate some key points that in 1995, the International Conference on Population and Development in Cairo recognized clearly, and for the public and for the global public, that reproductive rights are human rights, and that they rest on the recognition of a number of fundamental rights, including a woman's right to decide the number and spacing and timing of having children, and the right to attain the highest standard of sexual and reproductive health. And the conference also recognized that these rights are actually based on rights that are already recognized in international human rights treaties. This is actually not something new. Reproductive rights implicate a number of fundamental rights that are in the major human rights treaties. And these include the right to life and health, the right to equality, privacy, dignity, autonomy, and the right to information. But what I really want to focus on today is the right to health and access to reproductive health care. And in particular, my background actually, I spent a lot of time working as a practitioner and thinking about how human rights can be relevant to advocacy in the United States. And what I think that the recognition of reproductive rights as human rights has a tremendous potential to change the way that we think about reproductive rights and reproductive health issues, to change the way that these claims are made as a policy matter, to change the way that the society understands these rights. But I'm also particularly interested in ways that we can make the right to reproductive health and health care enforceable. And so the thing that I'd like to talk about today is the way to make how we think about enforcing social and economic rights. And the paper that that I'm trying to work on is a paper that will look at social and economic rights provisions in state constitutions and think about how we can look to developing international jurisprudence on enforcing economic and social rights and what lessons we can learn. And actually with me today is my colleague Jordan Goldberg, who's our state advocacy counsel, and I'm lucky to have her because she's actually my expert on state constitutions. So I want to take a step back, though, and talk about just the debate about social and economic rights and their justiciability. I think in the United States, when we talk about social and economic rights, there's sort of two types of arguments that we get about whether or not they should be enforceable. And I think the first argument is really a normative argument, that social and economic rights are really not part of our culture, it's not in our Constitution, and it's not really appropriate for us to be thinking about them as rights. The second argument, I think, is really more of a pragmatic argument, that it's really impossible for courts to enforce them, and that the nature of the decision-making when we're talking about social and economic rights always relates to the development of policies, and that's more appropriate for the legislative branch or the political branches of government. I just want to say a word first about this normative argument. I think that, while there are sort of arguments that, there's no right to health or not social and economic rights in the Constitution, I think that actually our popular understanding of rights in the United States actually is receptive to this idea of a right to health or other economic and social rights as rights that people are entitled to. A recent study that the Opportunity Agenda conducted showed that 72% of Americans view healthcare as a human right. And polls and studies also show that while we have conflicting views about healthcare and about the line between government and personal responsibility, that this right to healthcare resonates with the American people. And we can even think about the recent debates around healthcare and those town hall meetings where you would have people coming with signs basically saying, keep the government should keep its hands off of my Medicare. My Medicare, right? So there's sort of this idea that even though we think that, we're sort of conflicted about what the government's role is, people obviously really do feel like they have a fundamental right to health care at some level. But I want to put that normative discussion aside, although it's very interesting, and maybe we can come back to it, and really focus on the pragmatic issue of how we develop a workable system to make social and economic rights enforceable, and how we might use state constitutional litigation to do that. But before that, I do that, I also want to back up and just talk about how we understand social and economic rights and maybe why we have the arguments against why they're non-enforceable. I think historically there's been a view that civil and political rights are negative rights to be free from government intervention, and that social and economic rights are really positive rights that require government action. And that arguments about social and economic rights have really become intertwined in this debate, and this view that social and economic rights are unenforceable are sort of related to the fact that people see them as purely about positive rights obligations on the part of the government. More recent scholarship has really talked about how it's better to understand that all rights actually have civil and political rights and social and economic rights both have negative and positive components. And if you think about it, I mean, I think we have such a long history in the United States of enforcing civil and political rights that we sort of take it for granted, and we don't think about the fact that there's actually a significant amount of government expense in creating an infrastructure to enforce civil and political rights. If you think about the government infrastructure to protect the property regimes, or the government infrastructure and the expense that it entails to protect criminal due process rights. We take that for granted, but in fact it's a significant government expense. I think that there actually social and economic rights also have a negative component when the government takes actions to interfere with people's health care choices or their ability to actually realize their social and economic rights. And I'll talk a little bit about the negative enforcement about social and economic rights in a minute. So rather than categorizing rights as positive or negative, the international human rights community talks about 3 types of duties that all governments have related to rights, and Lance talked about those. Those are the duties to respect, which I think does correlate to this negative right that the government shouldn't be taking away your rights. Protect, which is really about the government's obligation to make sure that private individuals are not undermining your rights or getting in the way of your rights. And in the United States, there's no obligation for the government to protect fundamental rights, and yet it does it all the time. If you think about Title VII, that's really about the federal government saying that private actors can't discriminate. And then the last obligation is the obligation to insure, and this correlates somewhat to this positive obligation that the government has to help you ensure your social and economic rights. So most of the criticism about enforcement of social and economic rights concerns the positive enforcement of the rights. And the policy arguments, again, are really that the allocation of resources these decisions that are inherent in enforcing positive rights are really better made by the political branches. And I think this raises both legitimacy and competency issues. Again, I think the argument is, in terms of the legitimacy, that decisions relating to healthcare, education, social security, that these are inherently political decisions and that they should be better made by the political branches. There's also an argument about institutional competency and the view that that courts really aren't the best decision makers, aren't really the best place to locate decisions about policy, because courts typically consider cases brought by one plaintiff. They don't really have a full range of actors who are implicated in policies before them, that they are less able to do the fact-finding that's necessary to develop complex policies. I think these arguments are particularly persuasive in the U.S. context, again, because we're really more, we have more experience in the enforcement of civil and political rights. And I think part of the response to these criticisms is that we need to rethink the assumptions that we've made about the roles of the court and the political branches. And I think, first of all, for the argument, the legitimacy argument, I think, and the argument that policy decisions are better made by the political branches, I think when we're talking about rights and we recognize social and economic rights as rights, it's perfectly appropriate for the court to be involved in talking about social and economic rights, because that's the nature of rights, right? That rights are actually, to some extent, not political. It's sort of not up for grabs. When we as a society have made a decision something's a right, that often acts as a trump, and we don't necessarily yield to the will of the majority. And I think we have to, again, we have to recognize the enforcement of civil and political rights often involves decisions about the allocation of resources as well. In fact, if you think about it in the equal protection context, when a court rules that, that something's been discriminatory, a violation of equal protection, this often requires that the government change policies and then allocate resources in a different way. I think in terms of the competency issue, courts have ways of dealing with competency, this competency question in terms of getting information before through using special masters, through amicus briefs, through expert testimony. So there's ways around this competency problem. I want to talk a little bit about state constitutions and state constitutional litigation and why that might be an interesting opening for enforcing social and economic rights. Because I think while it's accurate to say that the federal constitution is really a constitution that protects negative rights, a lot of state constitutions actually have social and economic rights in them. And I think that if you look at state constitutions, their content is really varied, and it really often depends upon the context in which the constitutions were written. Some of them were adopted in the 1940s, and they were really influenced by the progressive movement, and we see social and economic rights provisions in the New Jersey Constitution, in the Montana Constitution, and others. I feel like I'm running out of time, so I'm going to try and go a little quicker. I think that in terms of the legitimacy argument, I think that there are arguments that the state courts and state judges are actually positioned differently in terms of the way the state governments are set up, that judges often are elected and they have a greater degree of political accountability, that state constitutions are actually much more commonly and easily amended than the federal constitution, so there's more of a back and forth between the people of the state and the Constitution and the judges. So I have about 5 minutes. I want to get to this idea of looking to jurisprudence from other countries to think about how we might enforce social and economic rights. So I've looked at a number of cases from South Africa where the court has decided a series of cases involving the right to health, housing, and Social Security. The South African court has been very clear to say that there are both negative and positive components of social and economic rights. And Jessie Hill actually has an excellent article talking about how we might think about this, the negative right to the right to health, and about how government's actions to interfere with people's ability to exercise their healthcare choices might raise violations of the negative right to health. And we can talk about that in more depth later. But I think the most interesting aspect of the South African jurisprudence is the way that they've developed a model to enforce positive social and economic rights, the positive aspect of social and economic rights. And what the South African court has said is that that courts have a role in judging whether government programs are to realize social and economic rights are reasonable. And the court, in making that determination, in judging whether programs are reasonable, the court has said that it needs to take into account the available resources and whether or not the government programs in place will progressively realize the right. And so there's sort of some key aspects to this reasonableness review. One, that it doesn't really create any immediate enforceable rights. So the idea really is for the government, someone challenges a government program related to the realization of social and economic rights. So it's not that that individual person will get a right to have some specific service given to them, but rather the court looks at whether the program is really progressively realizing the overall goal of achieving the right to education or the right to health. The court will show deference to the legislature, and it will often recognize that there's a wide range of possible ways to realize social and economic rights. So it's not that the court is going to say you should be putting this program in place, but the court will look to see whether the legislature in good faith has really adopted a program that really is going to realize the right for the population. And I think the other thing that we've seen is the court is really often hesitant to issue strong remedies. The way that it's worked is that the court will look at a program and it will say the program falls short of realizing social and economic rights for these reasons. And often there's a back and forth where the legislature will develop a program. It may come back to the court. The court will say, this is sort of progressively realizing the right or not. And there's a back and forth process, which I think is actually really important when you're thinking about a right that when the remedy for a right actually requires developing a policy and not just saying this is violating this particular right. The court has said, in order to give some teeth to this review, the court has looked at whether or not the government programs have actually been enacted in good faith. So there was a famous case in South Africa relating to the government's HIV policy, where the government, really took into account the fact that the South African government had been really denying the relationship between HIV and AIDS. And I think it actually led to a more strict scrutiny, a tighter level of scrutiny. The court has also said that any reasonable policy needs to take into account the people who are most affected and people who are in desperate need. So there was a policy, again, related to the South Africa looked at the government's housing policy, and there it found that the government actually had a good policy in place to build long-term housing, but the government failed to take into account the needs of the people who are currently homeless. So that any policy that really fails to take into account the needs of those who are in desperate need, the court said was unreasonable. The court has also said that reasonable policy can exclude certain groups. So again, in the housing case, the court said the fact that there were the people who are currently homeless who really, the government's policy didn't take into effect, rendered the policy unreasonable. The court has also said while the legislature has significant leeway in terms of creating a policy, that the means that it chooses can't infringe upon other constitutional and fundamental rights. So there was a case involving social welfare benefits where the government excluded lawful permanent residents, and the court said that was an unreasonable plan because it discriminated against lawful permanent residents. And it was actually interesting because the court said if the government had taken the position that lawful permanent residents were entitled to social benefits and it had a long-term plan to realize it, and even in the short term maybe they weren't getting the benefits, but in the long term it was planning to realize those benefits, that would be okay. The issue in the program that was problematic to the court in this case, COSA, was that the government said that it didn't feel that it was required to provide benefits. So it's sort of this idea that they had made the decision to exclude certain people from this program, but if they had made the argument that they actually had a plan to progressively realize the right for all, but then in the short term these people weren't getting the benefits, that might have been okay. So I'm going to actually stop there because I think my time is out, but would be interested in the question and answer period to sort of talk about the standard that South Africa has developed and think about how we might use it in the domestic context. Thanks.
Good morning, I'm Benjamin Meier. I use PowerPoint as a crutch, and I'm going to be presenting today on breastfeeding under reproductive rights. Thank you to Case for organizing this fabulous topic. I think it's ingenious of you to be thinking about these issues at the intersection of reproductive rights and health. Thank you to Sharona for the lovely introduction. I'll be speaking for about 15 minutes, again, talking about the issue of breastfeeding. So we know that despite millions of infants dying each year from the use of breast milk substitutes, formulas, baby formulas, International law has been unable to develop global policy, the global health policy that's necessary to ensure the protection, the promotion, and the support of breastfeeding. As international law has faltered in this policy imperative, human rights scholarship has been conspicuously absent on this pressing public health issue, with leading elaborations of reproductive rights neglecting this simple and obvious strategy for health promotion. In the absence of a foundation for human rights in breastfeeding, international law has wavered in regulating the global health harms of bottle feeding. Examining the shortcomings of international law in addressing this pervasive threat, my presentation seeks to analyze the incorporation of breastfeeding under the obligations of the human right to health, laying the normative foundation for rights-based global breastfeeding policy. And so, beginning with the public health evidence, this presentation reviews the research on breastfeeding's benefits for reproductive health, highlighting the harms of breast milk substitutes in the developing world. Following this background, I'll trace the evolution of global health policy in responding to the marketing of breast milk substitutes, and in breastfeeding promotion, protection, and support. Given the limited successes I've mentioned of these global breastfeeding policies, I'll outline a theoretical basis for incorporating a new human right to breastfeeding under the human right to health, delineating the rights holders and the duty bearers of such a right in a globalizing world. And to operationalize this right, I'll conclude by proposing a series of international legal mechanisms to translate this right into global health policy, and conclude by contemplating what it means to incorporate breastfeeding under the mantle of reproductive rights. And so, beginning with this public health evidence, with 10 million children dying every year, almost all of them in the developing world, every independent review of child mortality has pointed to the importance of breastfeeding for survival and for development. Given the infant death attributable to malnutrition and waterborne diseases, it's become clear that much of this avoidable suffering has resulted from the introduction of bottle feeding, with the child who's not breastfed bearing 14 times the risk of dying in the first 6 months of life. Expanding the benefits of breastfeeding, there's also evidence of direct reproductive and metabolic health benefits to the mother, reducing a variety of diseases and acting to postpone additional and inherently dangerous pregnancies up until the point of weaning. As a result, current public health recommendations propose exclusive breastfeeding for the first 6 months of life, with continued breastfeeding through 1 year, recommending this as the single intervention that could provide the greatest good to the greatest number of women and children, preventing 1 in 5 infant deaths, providing optimal nutrition for the physical and mental development of the child, and leading to improved maternal health. Yet despite these benefits, corporations have put these public health benefits at risk by introducing artificial formulas as the contemporary norm for infant feeding. With the rise of these corporations, the aggressive marketing of breast milk substitutes has led to increased advertising and sales in the developing world, even as this product has been increasingly shown to have fatal consequences. Exploiting ignorance through medical recommendations, and moving beyond that to overpower health education on the importance of breastfeeding. There's been increasing recognition over the last 30 years that this manipulative marketing is detrimental to global health. Yet despite the well-documented effects of these societal transformations on maternal and child health, developing nations have proven impotent to regulate the $20 billion infant feeding industry and to halt the unrestricted marketing of breast milk substitutes. As the benefits of breastfeeding and the harms of breast milk substitutes become clear, the scope of this harm becomes plain. The marketing of formula results in 1.4 million deaths every year and 10% of the global disease burden. 1.4 million lives per year could be saved through the protection, promotion, and support of natural breastfeeding practices. When I first began these conversations with the Carolina Breastfeeding Institute and my co-author on this project, I read this statistic and I said, what has global policy done to do this, to resolve this? She said, nothing in law. And I said, what the? We're recording. Mom, I'm sorry. And so I digress, but the actions of the commercial industry, the commercial formula industry, cried out for the creation of effective global health policies to restrict the marketing of breast milk substitutes as a means to protect, promote, and support breastfeeding. And as I mentioned, yet despite these evolving policy efforts to curb multinational corporations through human rights, early rights-based efforts to prioritize breastfeeding have regressed to abject neglect, with recent elaborations of the right to health failing even to mention breastfeeding. And so starting about halfway through the evolution that Lance presented, beginning with the harms of formula, which became clear by about the 1960s, breastfeeding would be taken up as an integral part of the right to health, incorporated as a critical component of primary health care in both the 1978 Declaration of Alma Ata and the 1979 Convention on the Elimination of All Forms of Discrimination Against Women, with the latter specifically codifying in a right to women's health the safeguarding of the functions of reproduction and adequate nutrition during pregnancy and lactation, seeking to support children's health through the proper nutrition of women. And so building from these human rights documents, the World Health Organization developed global policy standards to encourage breastfeeding by discouraging formula marketing, a process that resulted in the 1981 International Code of Marketing for Breast Milk Substitutes, a corporate code. Drawing on the right to health, the code opens by affirming the right of every child and every pregnant and lactating woman to be adequately nourished as a means of attaining and maintaining health. And so despite dramatic shifts away from primary health care at the start of the neoliberal era, breastfeeding would retain a prominent place under the right to health, with the 1989 Convention on the Rights of the Child obligating states to support the advantages of breastfeeding as part of a right to health now for both mothers and for children. But undercutting these evolving rights-based developments, breastfeeding advocates would shift the policy agenda from rights-based frameworks to a purely public health approach. And with breastfeeding advocates moving away from the right to health, employing public health indicators unbound by normative constraints. UNICEF announced in 1994 that it would abandon the right to health in breastfeeding policy, employing human rights only where the rights-based language supported preconceived public health goals. So where breastfeeding proponents abandoned human rights frameworks in favor of public health outcomes, human rights advocates received no support from these advocates to address breastfeeding under the right to health. And so as human rights bodies moved away from breastfeeding under reproductive rights, in the Cairo and Beijing declarations that we examined, and as Lance mentioned, General Comment 14 in 2000. General Comment 14 makes no mention at all of breastfeeding in its normative clarification of maternal, child, or reproductive health, effectively writing breastfeeding out of the right to health. With this loss of normative support under human rights, breastfeeding has lost its preeminence in the hierarchy of public health interventions, as what was once a leading public health success of the modern era has fallen entirely from WHO's revitalized primary health care agenda. And so against this backdrop of infant death, industry intransigence, and policy failure, health and human rights scholars have shown little interest in addressing these contentious policy frameworks for health promotion. in developing enforceable and justiciable global policies to stem this resurgent tide of breast milk substitutes in the developing world. My research finds that human right to health offers valuable normative frameworks for developing necessary international legal standards and implementing those standards through global health policy. To this end, support for breastfeeding comports with a capability approach to the right to health. Based upon the seminal thinking of Amartya Sen, scholarship has recognized policy imperatives for individual capability, seeking to remove barriers to freedom that leave people with little choice or opportunity to exercise their reasoned agency. Given its application to health capability, as defined by Jennifer Ruger, health policy should support individual opportunity to achieve health, emphasizing those determinants of health that structure a person's ability to be healthy, prioritizing those policies necessary to free individuals from escapable morbidity and preventable mortality. This capability approach provides an ethical basis for developing health policy and the progressive realization of the right to health, and a normative basis for grounding a right to breastfeeding within that right. In prioritizing breastfeeding under a right to health, a capability approach would seek to prioritize vulnerable populations in national policies, with breastfeeding overcoming the vulnerabilities of maternity and infancy that have been recognized in the Cairo and Beijing declarations. These vulnerabilities that exist in particular in the developing world and particularly among impoverished communities in the developing world. Improving agency for health between mother and child. And so in alleviating these vulnerabilities, policies should seek to protect individuals from the autonomy diminishing marketing of breast milk substitutes, thus moving individual agency to collective agency through public policy for the public's health. Thus, in public health environments in which harm is likely to occur from formulas, the right to health would prioritize underlying determinants of breastfeeding, supporting the regulation of sales practices, bless you, and where those sales practices are shown to be empirically harmful to the public's health in that region. And so given this interconnection between the infant's and the mother's health functioning, the rights holder and the duty bearer for this right to breastfeeding must be reconceptualized to encompass this intertwined reality. Based upon a capability approach to the right to health, I want to frame a right to breastfeeding as a pillar of the right to health, reconceptualizing the rights holder as the mother-child dyad. With this dyad, a collective unit making claims against the international community as a duty bearer for global health policies that are necessary to realize a right to breastfeeding in a globalized world. And so pursuant to such a framework for a right to breastfeeding, linking a rights holder and duty bearers through obligations reflective of the complex reality of breastfeeding in a globalizing world. States can come together with normative authority to create global health policy supportive of this right. International human rights law provides such coordinating institutions under the UN's authority for global health governance, including most prominently here state participation in global breastfeeding policy development through WHO's international lawmaking authorities. Secondly, statistical evaluation of breastfeeding outcomes by human rights treaty bodies. And finally, intersectional collaboration to mainstream breastfeeding throughout international organizations. And so examining WHO's international legal authorities, rather than developing codes of conduct for corporations, the protection, promotion, and support of breastfeeding will require the codification of rights-based global breastfeeding policy. For those globalized determinants of breastfeeding that are beyond the territorial confines of the state, like formula marketing and tobacco products before that, delegating international lawmaking authority through WHO offers states the opportunity to work collaboratively to create rights-based accountability, challenging the globalization of disease through the globalization of global health governance. To buttress these international legal frameworks under existing human rights institutions, the UN human rights bodies can consider breastfeeding as part of their larger enforcement of human rights norms throughout the world, particularly under the right to health. The UN human rights bodies provide unparalleled avenues for examining and influencing public health indicators, pressing states to report breastfeeding regulations, infant mortality outcomes, and providing the UN's imprimatur to NGO advocacy for breastfeeding. And given the synergistic components of a rights-based approach to global breastfeeding policy, such global breastfeeding policy necessitates cooperative obligations across international organizations, pursuing interdisciplinary approaches reflective of the complexity of the issue and embracing the indivisibility of rights, an indivisibility that's often proclaimed in human rights scholarship, but neglected in global health policy. And so echoing Professor, oops, I actually meant to make this all move. Okay, there we go. And so echoing Professor Gable's conclusion, whereas reproductive rights have long been construed as negative rights in the developed world, the health harms of reproduction necessitate a positive approach to reproductive rights in the developing world. Breastfeeding, under the human right to health, can be part of this positivistic vision of reproduction. In doing so, improving public health in the developing world through breastfeeding, reproductive rights can be brought to concern itself not only with the beginning of reproduction, but with the infant end of that reproductive cycle. Thank you very much. Look forward to your questions.
Okay, we have about 25 minutes for questions, so happy to take them. Huh? Oh, do we have students with mics?
Yes, we do.
Okay, because we are recording, we will need you to speak into the microphone. Go ahead.
Is this on?
Is it on?
Sorry.
Hello? Better? Okay, I guess this one's on. This question is for Professor Meier. I had some questions about your topic on breastfeeding. I guess I'm just still slightly confused as to, a lot of us were probably raised not on breast milk, but on formula. How does formula differ in the developed world from the developing world, number one? Number two, I'm still slightly confused as to the reasons that breastfeeding has gone down in the developing world, as formula undoubtedly would cost, you would have to pay to receive formula, whereas breast milk is something that is, well, already a plenty, if you will. And are there indeed, can there not only be made the arguments that formula does improve health? For example, it helps protect against the mother-to-child transmission of HIV/AIDS, which can be passed through breast milk.
Okay, there were 3 questions in that, and should I repeat them?
We have them on the mic, so
Okay,
we're okay.
so that's perfect. You make an important point. Breastfeeding is free, it turns out. It does require about 200 additional calories for the mother per day, although economists who have looked at this have found this to be considerably less expensive than the actual cost of buying formula. The question, of course, is why, if we were raised on formula in this country, although again, that's not the ideal for public health outcomes, it didn't kill us, but it kills people in the developing world. One of the lines of argument of corporations is that they bear no responsibility for their product, because while their product isn't, as good as breast milk, it says so on the package. They're not giving you something that is inherently harmful. Despite the lack of inherent harm in the product, it is consequentially harmful in that through practices in the developing world, these formulas are powdered and they're mixed with water in the developing world. The water is unsafe. The diarrheal load is what causes babies to die. The second cause of baby death, of course, infant death. I'm still working on my public health language. The second major cause of infant death is malnutrition. More often than not, breast milk substitutes are marketed in the developing world by giving out samples to new mothers in the hospital setting, where of course it is safe and healthy. It's like giving a child a cigarette. You bring a woman into this, they're into the breast milk substitute world, they're giving their child the free formula samples, and then the samples run out. At that point, the breasts are no longer producing milk. And so you have an unhealthy dependency on the formulas. And what happens is one of two things. Either the money runs out and the child stops getting any nutrition at all and dies, or what mothers end up doing in practice, and the evidence is that they increasingly dilute it as it gets closer to the end, which is both not providing a child sufficient nutrition and, going back to the water problem, further exposing the child to infectious disease. The last issue, and this has become a bit of a fixation within the human rights community, is that children have a right not to be exposed to HIV, and there is a risk of exposure from breastfeeding. The first response to this is the public health response, that the children who get HIV through breastfeeding are more often than not children who are not exclusively breastfed. For reasons that are somewhat complex biochemically, exclusive breastfeeding does not pose the same risk of HIV transmission as mixing breastfeeding with formula feeding. And the second is the larger consequentialist human rights analysis, which is that public health indicators suggest that the risk of a child dying from HIV is still considerably less in most environments than the risk of the child dying from unclean water conditions based upon formula feeding. So at the end of the day, until we can figure out a better way to get clean water to the developing world, these products are consequentially harmful. They're creating unhealthy dependencies, and they're killing millions of children every year. And so human rights should be playing a larger role in thinking about these issues. And when this issue was first brought to my attention, I was surprised, I was shocked, and as I write this article and redraft it, the shock sort of drives me on.
Okay, Professor Davis? Right here, Professor Davis. I'm sorry.
I'm completely with you on everything you've said so far, but I'm curious to know, Professor Meier, what kind of legal action you could imagine a country such as, say, India or Thailand or whatever taking, in part because a complete ban on formula, I mean, there are situations in which formula is appropriate. So a complete ban, treating it like heroin or something, even assuming that that would work, doesn't seem realistic. So can you give me at least one example of a concrete piece of legislation that you would envision?
I can give you a couple attempted examples. Countries have thought about making this a prescription-only type of substance. If it is necessary, there are women who do not lactate. In those situations, through medical assistance, one can obtain formula. But formula is not the norm. Formula is the medicalized solution for a problem, the problem of an inability to breastfeed. Many countries have attempted this. Part of the problem is this $20 billion industry, which has often stymied national attempts to legislate. And this was similar with the Framework Convention on Tobacco Control. Tobacco companies were perfectly comfortable going country to country to prevent regulation. They have a harder time preventing regulation when it's done at a global level through the World Health Organization. So I'm pushing this WHO's Article 19 authorities to draft international law to prevent this.
Was there a question Denise?
No, he answered.
Hi.
Okay.
Given the bifurcation of human rights into the two broad categories, and this is a question for the whole panel, I'm wondering why it is that the right to health and reproductive health is kind of pushed into the secondary level of economic and cultural rights, as opposed to at the more primary level where there's a lot more observation by governments in the civil political arena, since it seems that this is such a individual right that it'd merit being a civil right. Does anyone have any comments on that? And what would be the driving force for keeping it out of the primary level of human rights?
Well, I think that you're absolutely right that reproductive rights actually implicates a number of rights, and it implicates key civil and political rights, equality, non-discrimination, autonomy. I feel like those are arguments, though, that we've been making for a long time. Those are arguments that we've been making in the United States. And part of our interest, I think, in thinking about the right to health is it's not. Increasingly, what we're seeing in the United States is it's not just a question of whether services are legally available, but whether people have access. And I think this issue of the right to health and the government's obligation to make sure that people are actually able to access their rights has become increasingly important as we think about women of color, as we think about poor women, as we think about restrictions that we're seeing on abortion care that really aren't about making abortion illegal, but making it very difficult for providers to stay in business. So this idea that the government has an obligation to make sure that people have access to services actually opens up a broader range of advocacy and a broader range of policy responses.
And I'll actually add to that with a little bit of the history underlying this. Lance actually began this talking about the Universal Declaration of Human Rights in 1948. The goal was to create a single body of human rights. But through political conflicts of the Cold War, this universal concept was bifurcated into two opposing conventions or camps: the negative rights in the International Covenant on Civil and Political Rights, and the positive components in the International Covenant on Economic, Social, and Cultural Rights. With the end of the Cold War, it was thought that this bifurcation of rights had ended. And so at the end of it, new treaty law was drafted to recognize the interdependence, interconnectedness of all human rights. And so rather than trying to reposition health as a negative right, as a civil right, it's best that we move in a direction of international law where we can consider all of these rights to be equal and interdependent, working together to create a synoptic vision of underlying determinants of health that encompasses both these negative and positive conceptions.
Yeah, and I think there's a good opportunity, a very strong opportunity to do that now with some of the normative developments that have gone on in explaining the right to health as such a broad concept. So I think that some of the recent efforts to try to broaden that understanding of the right to health actually do in some ways go in that direction of more explicitly recognizing both the economic and social components and the civil and political components. And I think it can also be said that there's a very strong ethical case to be made that in some ways having protection of health is equally as fundamental as any of the other civil and political rights, because without health, you can't even benefit from the existence of those other civil and political rights.
So let me ask a follow-up question. If it's not a negative right, but rather it's somehow a positive right, does that imply that the government actually has to provide something? And if so, where do we draw the line? How much cost do we require the government to absorb, and for what should it pay?
Well, the way that's an excellent question. That's usually one of the main arguments against recognition of economic and social rights, and it's the argument that's raised frequently in the United States to justify the fact that we haven't ratified the International Covenant on Economic, Social, and Cultural Rights. That it would be expensive. That it would be hard to, if individuals had a right to claim access and affirmative responsibility of the government to provide certain health resources, that it would just open the floodgates and there would be no end to what would be required in terms of expenditures on fulfilling those rights. Now, in the international treaty law that establishes these rights, there's this concept of progressive realization. We've mentioned it a couple times, and that's the idea that a country who is responsible for protecting and upholding the right to health doesn't have to get all the way there right away, but as long as they're moving in the direction of fulfilling that right, and they're doing it within accordance with their resource constraints, they still can be seen to be not in violation of that right. Of course, that's a really complicated question because there's strong arguments that could be made on either side as to what is a sufficient level of resources to be allocating that would meet that progressive realization standard.
Yeah, and I would just add, I think it's sort of important when we're talking about human rights treaties that, the points that Lance made in terms of progressive realization, and also when countries become parties to international human rights treaties, they have an obligation to comply with the duties that are under these treaties. But it's up to the states, the countries, to think about how that's going to happen. So let's say, if we had ratified the Covenant on Economic and Social and Cultural Rights, that would not mean that people could immediately sue in court and claim that these rights have been violated, but rather the government could have an obligation to adopt policies that would further these rights. So, it's sort of up to the states whether they're going to make rights immediately enforceable or whether they're going to pass legislation that would lead to the progressive realization.
And I would actually take it a step further. I think we're putting a lot of obligations on the state, which in many of our cases is the developing state that lacks the capability to even begin fulfilling some of these basic needs. In a globalized world, what use is the state when we've got a perfectly good international community out there? Human rights is premised on this idea of a state duty bearer, with the original idea that why would we concern ourselves with global duties when states are solely responsible for the health and well-being of everyone within their territory? I think that globalization has laid bare this hermetic notion of sovereignty, and given the interconnected world in which we work, the pathways through which aid flows from developed to developing countries, we need to look at human rights bases for constructing foreign aid programs, lending of international economic institutions, and the programming of international organizations within countries.
Dean Anton.
I actually have, I hope, a short question for both Ms. Soohoo and Professor Meier. Ms. Soohoo talks about using state constitutional positive rights as a way of litigating for health rights. Almost every state constitution provides for a positive right to education. There's been a lot of litigation in that area with mixed results. So I guess the question is, how should we think about the prospect of health litigation in light of the experience we've had with in the education area? And for Professor Meier, on breastfeeding rights, we're talking about breastfeeding internationally. To what extent do we protect breastfeeding rights in the United States? There seems to be kind of a mixed bag on that too, at least with the cases that I know about.
That's actually an excellent question, because I think the place where we've seen the most litigation in terms of trying to enforce social and economic rights have actually been these education and school funding cases. And I think, we're actually just starting to really delve deeply into those cases. And it's interesting, though, because I think you could say there are a lot of similarities between the model in terms of the way that litigation has progressed and what, the sort of suggested model that South Africa has developed. Because you've sort of seen that what will happen, like in the case of New York, will be that, the Court of Appeals will sort of say, in that case, they found that the New York City students had a right to a sound basic education. And then there's sort of a back and forth about what that might require. And the court said that it was really up to the legislature to figure out how much it would cost. And there was a whole process that the legislature engaged in, and back and forth. And in the end, there was sort of a dispute about what that cost would be. and the court said that it would give deference to the findings of the legislature and the governor. But there was actually a long process, and I think that's sort of what we've seen in South Africa, where the court says, this right has been violated. Now it's up to the political branches to think about, well, how do we create a system that actually will realize these rights?
With regard to breastfeeding in the United States, we are not a whole lot better than the rest of the world. I mean, we took a really good stab at it in 1978. Ted Kennedy held a series of hearings in the Senate trying to create national regulation to reduce the use of breast milk substitutes in this country. When it came time for the World Health Assembly to sign the International Code of Marketing for Breast Milk Substitutes, the United States was the only country in the world to vote against it. To a certain extent, we are the embodiment of the breast milk substitute corporations, with the exception of Nestle, which is headquartered in Switzerland. So the United States and Switzerland tend to be the sole bulwarks against the promotion of breastfeeding. That said, the reason I talk largely about the developing world is because while breastfeeding is the ideal for both the health and the mental and physical development of the child, and so people who are formula fed in this country are at a disadvantage throughout their lives. I'm sorry. It doesn't kill people here. It's not ideal, but it's not deadly. And so I focus on the low-hanging fruit in this arena.
Professor George.
Hi, this is a question perhaps for Professor Meier or the entire panel. You spoke about, in the Q&A, we've had some conversation about globalization, the decline in sovereignty. With respect to the roles of rights and duties, the concurrent duties or responsibilities, the place of the non-state actor, I'd invite you to unpack a little bit more. So what is the responsibility of a Nestle or a multinational corporation? How might they ameliorate some of the disadvantages in accessing the right to health, or how might they exacerbate some of the difficulties we have in achieving and realizing this right? So I guess my question, it goes to what is the role of the corporate non-state actor in questions of access to the right to health? You seem to talk in parallel about initiatives that the World Health Organization is engaged in to make things binding. What there seems to be in this kind of governance gap where corporations are entering is a lot of voluntary codes. So is that an avenue for getting greater, what would it be, responsibility, or would it be a hard obligation, and where would it emerge from? How could you articulate some standard of how we think about the relationship of the non-state actor to realizing rights when arguably they're not state parties to any of these rights?
None. There are no obligations on non-state actors, these corporations that we're talking about. These are not duty bearers under international law, although people are making very good arguments in scholarship now that they should be. Part of the problem here in creating the voluntary codes, and the International Code of Marketing of Breast Milk Substitutes is a perfectly good example of it. You are left with actors who are not monitored, they are not reporting, they are not held to account except by NGOs. There is some naming and shaming that goes along with that, but not nearly to the same extent that we have in the regimented human rights system. So if we can't put obligations on non-state actors, how do we regulate them? Well, the answer is not to give them safe haven anywhere in the world. Corporations can move from place to place. So in cases in which people can have this race to the bottom to find the place with the least regulations over their practices, we need to create truly global regulations so that there is no safe haven for harm.
The other thing I think we might think about is, the state has an obligation to protect, right? And so, the state, I think, under a human rights regime, should be doing more in terms of regulating private actors. There was actually an interesting case in South Africa called the New Clicks decision, where the government actually imposed a regulation that created a fixed dispensing fees for pharmacy. So the idea was that in order to make medicine available, that pharmacies could only charge a certain amount. And there was sort of, it was interesting because there it was a dispute between the property rights and the rights of the pharmacy and the right to health. And it was interesting because there the court actually engaged in sort of this balancing of the two rights. So I think the other thing is when we recognize a right to health and we're sort of judging the appropriateness of government regulation, it sort of creates a counterweight to sort of individual or property rights. And so it changes the calculus when we're sort of judging whether government action is appropriate, when the government actually wants to promote a right to health.
So I think we have time for one more question. Go ahead.
I would like to speak as an obstetrician gynecologist who is a strong advocate of breastfeeding and the thousands of babies I've delivered in this community. So that said, our bigger problem in the undeveloped countries is the maternal mortality. There's a huge maternal mortality so that many of these babies wind up as orphans. Some of them, of course, die in utero with their moms. Many of the mothers afterwards with hemorrhage, infection, what have you, leave babies as orphans. So this is a huge problem in the undeveloped country. We need very desperately to treat the moms. Treating moms for AIDS is very helpful to the babies. No question that breastfeeding is fabulous for the immunology and the protection of infants in the first few months of life particularly. I'm wondering about increasing a new industry for the wet nurse by taking moms who have been able to successfully breastfeed babies, being absolutely certain of their good health, and protecting the babies whose moms cannot nurse them instead of giving them formula. And I never hear anything done about this, and this might be a perfect opportunity to give some income to some moms over in the underdeveloped country, protect the babies. Important thing to do is, number one, take care of the moms. We're not doing that. The mothers' maternal mortality is unbelievable over there. If we don't have a mother, we can't have a baby nursing. So these are my suggestions for looking further into a couple of other options other than just getting mad at the infant formula people.
And I couldn't agree more with that sentiment. I think we spend a tremendous amount of our aid dollars to the developing world on formula. Instead of feeding children formula, we should be feeding mothers food, allowing the process to take place naturally. As far as the idea of wet nurses is involved, I do address that in the article. I think it's a great way of thinking about this issue. While mothers don't have an obligation to breastfeed, children clearly have a right to be breastfed. And whether this is done through breastfeeding, whether this is done through wet nurses, whether this is done of this new idea of milk banks, where there's a pooling, and I don't really know much about it, but you get the idea. I think that this is a way of moving forward with policy proposals in order to improve maternal and child health as a symbiotic dyad. And to amend something I said in response to the last question, I kind of poo-pooed on NGO efforts. Part of the reason that the Code of Breast Milk Substitutes was developed was because there was a worldwide boycott of Nestle products, and some of us are old enough to remember that boycott. People do influence corporate behavior, so it's not as effective as true human rights obligations and reporting to human rights committees, but when it's the best we got, it's not so bad.
And I just want to just make one comment about your point about maternal mortality and the importance of that. It's not something we've talked about very much explicitly on the panel today, but I think it goes to the broader context of what we're talking about in trying to link the right to health and reproductive rights. That reproductive rights raise implications for the right to health all throughout different aspects of the reproductive cycle, and so. Maternal mortality has been a focus of global health policy in the sense that it's one of the Millennium Development Goals, is reducing maternal mortality. Now, there's been some success along those lines, but not nearly enough. And that's something the Millennium Development Goals are coming up for completion in a couple of years. There's also going to be in 2015, it's going to be the 20th anniversary of the International Conference on Population Development, which originally linked reproductive health with human rights. And that's another, both of those initiatives are opportunities to, again, inject this right to health discourse within international policymaking and to highlight things like maternal mortality in particular as being really fundamental components to achieving the right to health.
Well, thank you to a terrific panel.